Welcome to All Things Social Security. Enjoy your video. Jennifer says, any tips for the hearing? Oops. Well, Jonathan's going to tell you, or I guess, or maybe one of his staff, be yourself. Don't be shy about telling exactly how it is. I do always say, go over your function report. Those are a lot of the questions that a judge might ask. In some way, shape, or form, he might cherry pick depending on what kind of evidence he's seeing in the file. He's not going to pick the irrelevant ones. So I would review those and see what your current see if your answer today is different from when you submitted that function report. Is it worse? Is it better? If it's better, because he asks those questions and you're going to say something better than what you had before, you might have a qualification to that. That would be relevant and more favorable to also explain what that improvement or whatever. Also, if your work history is relevant, if you've had work in the last 5 years, I want to make sure that you have don't go skimpy on any of the arduous physical natures of that job. Physical. I do see people a lot of time, because they mostly had a sit-down job, they say they didn't do any lifting, and when you dig into it, well, not a lot. Every week I had to empty the garbage bins. How much do they weigh? Probably like 30 pounds. Now you have a 30-pound weight limit. That means your job was medium level. It wasn't light and it wasn't sedentary, and that helps you prove you can't do it anymore. Knowing what those things are, and that saying you didn't lift anything when you did once a week is important to show that you couldn't do that job as performed. And it's just one of the tiers you have to prove. I would just make sure you got that all kind of ironclad. Okay. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hey, so you're heading into an ALJ hearing, and maybe you want to know, are there things I really shouldn't be saying in there that might seem natural for me to say otherwise? I think there is. There are some kind of cringeworthy things that are sometimes said. So I just want to go through a few of them that I have to stand out in my mind. And in the regular world, they might seem innocuous, maybe annoying to some people, but otherwise innocuous. But I think when you're in a hearing, you really don't want to have cringeworthy. And by that, I mean where your lawyer or your non-attorney rep is sitting there going, oh, God, in their head going, I wish she just didn't say it that way, or, So anyway, one of the things that stands out in my mind is a client that could not quit the habit of saying, to be honest with you, Judge. Well, to be honest, I think it's the same client that used to say, not for nothing, Judge. But anyway, the whole point about saying, when someone says, to be honest with you, or another similar thing might be, I'm going to be totally candid with you, or to be frank with you. I know it's just a habitual way of speaking, and it doesn't mean that you're a liar normally, and now you're going to try to be good. But think about the implications. You're basically saying to the judge, I'm going to be honest with you with what I'm about to say. That doesn't make it so favorable as to what you've been saying, other than what you're about to say, if you have to preface this new phrase with, to be honest with you. And again, I think it's just like a speaking habit some of us have, but it is cringeworthy to me if you're at a hearing. And I actually, when I prep my clients, we generally go through, if I happen to know they have certain expressions that they use, just habits, and some of them do. And I usually have them in the back of my head, and I say, listen, I know this is something comes out of your mouth all the time, and I don't want to put this extra pressure on you, but you might want to just avoid using that expression when you're with a judge. It just doesn't give a flavor of being, of course, and always an honest. I mean, you're under oath. You know what I mean? You really shouldn't go under oath and then say, okay, now I'm going to be honest with you, Judge, about this one thing. You see what I'm saying? It just doesn't float too well. Another expression people use, and I think it's when we're frustrated and it's maybe a little defensive, but to say something like this to the judge, and it could depend, it could almost be with any impairment or any symptom, but I think the one that I heard about it was about depression. Now, of course, depression is one of the hardest things to win on, because so many people have it who are still able to work. So to prove that you are not able to work from it, it's really, really tricky. Because again, most people can work with it. So most people with depression are not going to be eligible for SSD, and rightfully not. But anyway, assuming you have a case where all things combined, you're unable to work, not necessarily just because of the depression, this expression, I think, is a complete turnoff. I don't know if you know what it's like to have depression, Judge, but let me tell you, it is not fun. I don't know if you know what it's like, Judge, to have chronic pain, but let me tell you, it's so snarky. And you don't know what that judge goes through in his or her day-to-day. I mean, a lot of them are well over the age of 25, and we all seem to get impairments as we get older. Those impairments are not unusual for working people. So when you say something like that to a judge who probably might have a little bit of his or her own chronic pain, not disabling yet, but nonetheless are probably very familiar with what it's like. Plus they hear hundreds and hundreds of cases, in a relatively short period of time. So to suggest that they don't know anything about the actual thing they're adjudicating, I think could be do I think it's going to make them deny your case? No. But if you are on that little fence, like this is what many cases are, do you really want to tick off the person that's making the decision? I don't know if you know what it's like to be a judge. What I'm saying is it's insulting to a judge who is hearing and or has heard hundreds, if not thousands of cases, has seen heartbreaking cases, has seen cases probably worse than yours. And you're sitting there saying to the judge, I don't know if you know what it's like, Of course, he's not in your body and he knows that. But don't try to suggest that he doesn't know, the nature of his job, what his job is, and what his job is to know about and to consider. And also don't forget that the crux of the proving of your case is from your medical records about your depression or whatever the chronic pain. So if you haven't convinced your doctor to be very articulate in your records about your day-to-day issues with it, the best time is not to try to drill that home to the judge. You have your ways during testimony to explain how your pain is, but I wouldn't use the expression, I don't know if you know, Judge, what it's like to have depression. I don't think it's going to fly well, by and large. Okay, another one. This was cringeworthy. All right, so the expression was along the lines of, Judge, I can barely feed my kids. So there's on a few fronts, this is, I think, not the smartest thing to discuss. The judge is aware that most people are financially struggling when they are relegated to not being able to work and are seeking Social Security disability. Not everybody. There are wealthy people. It's our insurance we bought. So we're all entitled to file a claim should we meet the criteria, which is we're unable to work. All right. So, and it depends perhaps on the context. In this particular case where it was cringeworthy was the person was married, several children. The children were homeschooled, just as an aside, and this parent stayed home with them. This parent was very impaired. I actually thought he should have won, but I'll tell you, this person did not win. This is many, many years ago. And in one sentence, he's asked, about his smoking because he smoked cigarettes. And we all know how expensive that is. And I'm not judging people for being smokers. I was a smoker myself many years ago. But, to in one breath be talking about how you're smoking, which we all know without having to say it, that it's costing a lot of money. Either you're getting money from somebody to buy them or you are spending your own money to buy them. Either way, then you're saying, I can barely feed my kids. So, and I think this person was saying that they feed them peanut butter and it was embarrassing, which I didn't understand because I think peanut butter is great. It's actually a really good food, but it just might not fly too well when you're spending money on something very detrimental to you and even more so unnecessary. And it almost implies that you're doing so at the expense of feeding your children because you just said you can barely feed your kids. So you almost have to really think about what you say and be intentional with what you say and not just say things for sympathy when it really could actually come back and boomerang on you. What was the other thing? Well, kind of like the one about the depression. I don't know if you like to have if you know what it's like to have depression, Judge. But another just blanket one is or telling a judge, you don't know what it's like. You don't know what it's like. Again, it's that whole just general telling him what he knows or what he doesn't know is probably not a good direction to go in for a guy or a woman up there who has been doing this for so long. And oftentimes they practiced, I think, before they started doing that. So they know, they know a lot and they know what your records say about you. So don't be so sure they don't know. Your records may or may not reflect what you're saying. They might reflect something inconsistent with that. And that's kind of on you to make sure that your records are as strong as they can be and reflect accurately your limitations and your symptoms and the nature of your impairments. So that is what he's going to be going on. If you have problems with your records and something's inaccurate, well then, yes, by all means address it. In fact, you should probably address it with your medical provider who made inaccurate records, right? But I would be careful about going strong at a judge at your hearing. You don't want to make an adversary out of your judge who is not your adversary. This is not an adversarial process, they tell us. So just choose wisely. You get more bees with honey, that whole thing. I don't want to go too long on this, but those kind of expressions, where you're kind of almost going on the offensive, but you're with the judge who's making the decision. You want him on your side, not to be ticked off at you or, we're all human, right? So I would steer clear of these kind of expressions where you are kind of insulting him And I know you don't mean to, right? It's just some of these things are just a way of speaking. And of course, the thing about, I'm going to be honest with you, Judge, implying that you're not necessarily usually, which would mean like all the rest of your records are suspect, right? All the things you say to your doctor. So anyway, just a few things there. I'll probably do another one of these with a few more specific things, but I want to keep this short. Anyway, if you have any goodies that you can think of, maybe you made a blooper in a hearing and you care to share it confidentially, of course, I'll be happy to put it out there and why it might not be a good idea. All right, I'll talk to you later. Bye, guys.